Hello, my name is Kathy Arrington, and I'm the supervising attorney for the Guardian Ad Litem program of the First Judicial Circuit. Today we're going to be talking about the legal path of a case, how a case begins in the dependency system, all the way through to its conclusion. We're also going to be talking about the grounds for termination of parental rights, as well as the factors relating to the manifest best interests of the children in a termination of parental rights case. The majority of dependency cases begin with a call to the Florida Abuse Hotline, a call made by someone who has knowledge of a child who has been abused, neglected, or abandoned by the child's parent or caregiver. Once the call is received by the hotline, a child protective investigator from the Department of Children and Families is sent out to investigate the allegations. The investigator may speak to the child, may speak to the parents, may speak to doctors, teachers, daycare workers, in essence, anyone who has had any contact with the child and may have information pertaining to the allegations. The investigator makes a determination at that point as to what the next step is going to be, and there are basically 4 ways that an abuse call is resolved. The first is that nothing happens. The investigator determines that there is no basis to find the child dependent or to take the child into custody or require that any services be embarked upon by the family. The second possibility is that the investigator determines that while there are some issues that need to be addressed with the family or with the child, it doesn't rise to the level of a judicial case or even what they call a voluntary case. The investigator may make some referrals, daycare referrals, food bank referrals, clothing referrals, and the case goes no further. The third option is the investigator determines that it's not necessary to bring the matter before the court, but the family does need assistance and needs to be monitored during that assistance period. What the investigator can do is refer the case to the CBC, which is the agency locally, Families First Network, that has responsibility for protective services supervision, and request that entity become involved, set up a voluntary case plan, set up a safety plan to assist the family in resolving the issues that brought the case to the attention of the investigator. Those cases initially do not become judicial, and if the family successfully completes all of the voluntary case plan requirements, even though it is voluntary, the case goes no further. The fourth option is that the investigator feels that the court does need to become involved with this family, and there are 2 ways that the case can go. If the child is in imminent danger, the investigator can remove the child from the parent or caregiver, place the child in a shelter placement or with a family member, or potentially leave the child with one of the parents, and a shelter petition is filed and the case comes before the court. The second option that the investigator has is to leave the child with the parent or in the child's current placement, but file what's called a dependency petition without shelter, and again bring the case before the court, bring the matter to the court's attention. There are occasions where families enter into voluntary protective services or voluntary case plans. They don't comply, the situation does not become resolved, and that case can then go judicial after the investigator and Families First Network have attempted to work with the family to resolve the issues. If a child is removed from the parent or the caregiver and placed in shelter, it's important to remember that shelter is a status. There's not a home in Pensacola that's a shelter home where all children that are removed from their parents are taken. Shelter is a status. And a child that is sheltered can be placed with a family member. They can be placed with a non-relative. At times they may be placed with one parent over the other if the allegations only pertain to one of the parents. Or the child can be placed in a shelter placement, which is in essence a foster home. If a child is placed in shelter, the department is required to bring the matter before the court within 24 hours after the child has been placed via the filing of a shelter petition. And at that shelter hearing, again, which must take place within 24 hours, the court must determine whether there is probable cause to believe that the child needs to be removed, that there is a reasonable basis for the child to be removed from the parent and placed into shelter status. If the child is sheltered, the Department of Children and Families must file a dependency petition within 21 days. The next step in the process is what is called an arraignment, and dependency borrows a lot from the criminal system. Arraignment is a hearing that's held in criminal where the accused comes in and enters a plea to the charges that have been leveled against the accused. In dependency, the parents come before the court, and again, they enter a plea. Pleas are a little bit different. In dependency, the pleas are either an admit plea, a deny plea, or a consent plea. If the parent enters an admit plea, they're admitting to all of the allegations in the petition, in the dependency petition. If the parent enters a deny plea, they're denying all of the allegations and they are requesting that a trial be held. If they enter a consent plea, they're not admitting to the allegations of the petition, but they are admitting that their family is in need of services and their family is in need of court supervision. If the parent enters a consent plea or an admit plea, the next step in the process is what's called a disposition and case plan approval hearing. At that hearing, the court will, in essence, dispose of the case. The court will determine whether or not the child should be adjudicated dependent, and if a child has been removed from the parents, the child must be adjudicated dependent. If the child has been left in the care and custody of one of the parents, the court has the ability to withhold an adjudication of dependency, and if the parent successfully complies with the case plan, the case can actually be dismissed within a 6-month period or a year period, and it is as if the dependency never happened. However, that's not a given that the court is going to do that in every case, and there are cases where children are left in the custody of the parents, but nonetheless, the court enters an adjudication of dependency. At the disposition hearing, the court will also determine what the case plan goal is going to be, what the ultimate goal for the family is going to be. The court has a number of options in that regard, but the majority of cases that we have a reunification case plan goal. If the child has been removed from the parent or parents, if the child remains in the custody of the parent, the goal is going to be a maintain and strengthen case plan, which in essence is trying to maintain and strengthen the placement with the parent by the provision of services and the parent working on a case plan to address the issues that brought the case before the court. A few other options that the court has that are rarely used at the earlier stages but can be used based upon the circumstances of the case are an adoption goal, a permanent guardianship goal, placement with a fit and willing relative, or a goal of another planned permanent living arrangement. But we'll get to those goals in a few minutes. At the disposition hearing, the court will have the case plan, will accept the case plan, accept the tasks that are outlined in the case plan. The court will also establish visitation for the parents with the child if the child has been removed from one or both of the parents. A case plan, in essence, is a contract. It's a contract that the parent enters into, agreeing to perform the services or engage in the services that are outlined in the case plan that will help address the issues that brought the case before the court. One of the primary services found in case plans in our area is the parent undergoing what is called a biopsychosocial assessment or a family care assessment. The parent will be interviewed and evaluated by a licensed mental health professional who will then determine what services are necessary for that parent to address the issues relating to abuse, neglect, or abandonment of the children. Those biopsychosocial assessments, which are then incorporated into the case plan, can have recommendations ranging from the parent engaging in parenting classes, the parent undergoing a domestic violence assessment and complying with any recommendations from that assessment, if domestic violence was an issue that brought the case before the court. The biopsychosocial assessment can also incorporate a substance abuse assessment, and then the assessor will make a recommendation, if substance abuse is an issue, as to what level of treatment the parent should undergo to address their substance abuse issues. The biopsychosocial assessment can also recommend parenting classes for the parent based upon the way that the assessment ends up. There are a vast number of services that the biopsychosocial assessment can recommend. In certain cases, for example, those cases where there's a long history of domestic violence, a domestic violence assessment may be incorporated in the case plan without the need for the biopsychosocial assessment. It all depends on what the individual circumstances of the family and of the case involve. If a parent enters a denial at the arraignment hearing, which again is held very early in the case, the next step in the process is to schedule the matter for trial. There are occasions where the parents request or the court orders that the parties submit to mediation. And mediation is a process where the parties sit down with a trained, certified mediator and attempt to work out a resolution of the case. Many of our cases that go to mediation do get resolved at mediation. However, if the case cannot be resolved at mediation, or for whatever reason mediation is not ordered, the case will be scheduled for trial. In the interim between the arraignment hearing and the trial date, the court may hold what's called a pretrial conference in an attempt to determine what issues are out there. What things can the parties agree upon? Who are the witnesses that are going to be called by each set of parties in the case? In essence, an attempt to streamline the trial as much as possible. If the parties deny and the case sets the matter for trial, we would then go to what's called an adjudicatory hearing. And that is where the court determines whether or not a finding of dependency is going to be made. The Department of Children and Families has the lead in those trials. They present the evidence, and they are required to prove to the court by the greater weight of the evidence as to whether or not the child should be found dependent. If the court determines the child is not dependent, that the department has not proven its case, or that the facts relating to dependency are not there, the case is dismissed and there are no further proceedings in the case. If the court determines by the greater weight of the evidence, and to kind of visualize what greater weight of the evidence is, picture a scale, and the scale just needs to tip slightly in favor of a finding that the child is dependent. If the court determines after the trial that the child is dependent, we then move to the disposition hearing following that adjudicatory hearing, and the same things occur at that point as if the parents had agreed to dependency in the first place. The court will adjudicate the child dependent, the court will approve a case plan, the court will set a goal, the court will set up visitation. Hearing in the case after the disposition hearing, where the child is adjudicated dependent, the case plan is approved, is what is called the initial judicial review hearing. And that is held 90 days after the disposition hearing, or the date the court approves the case plan, or 6 months after the child has been removed from the care and custody of the parents, whichever occurs first. At that initial judicial review hearing, the Department of Children and Families will file what's called a Judicial Review Social Study report, and that report will outline how the parent is doing on their case plan. The Judicial Review Social Study report lists all of the case plan tasks and then advises the court in writing as to how the parent is progressing on each one of those tasks. The Judicial Review Social Study report also will include information about how the child is doing. It will include any information regarding the child's health, child's doctor appointments, dentist appointments. If the child is in mental health counseling, it will advise that the child is in mental health counseling and who the child is seeing, as well as any diagnoses that the child may have that have been developed by a mental health professional. The Judicial Review Social Study report will outline the parent's visitation, whether the parent is engaging in visitation, how that visitation is progressing. It will include the standard immunization record that is on a form by the state of Florida that doctors who are providing immunizations will document the immunizations that have been provided. The Judicial Review Social Study report usually also includes, for children that are school age, what their current school records are, both pertaining to grades as well as their attendance at school. The Social Study report may also include information from daycare providers if the child or children are in daycare. Basically, it gives the court an update on how the family is progressing, how the children are progressing. These Judicial Review Social Study reports are to be filed 72 hours before the date of the hearing and are to be served on all parties to the case. At this point, the Guardian Ad Litem program also should be filing a Judicial Review Social Study report of its own, where the individual Guardian Ad Litem or the Child Advocacy Manager will be filing a report outlining what they've observed, their visits, information that they have gathered during this time frame. The Judicial Review Social Study report will also provide what's called a prognosis as to the parents' progress on the case and the likelihood of reunification if the children have been removed. If the children remain in the care and custody of their parents, that prognosis is really not an important part of the Judicial Review Social Study report unless there are some problems with the parents' compliance with the case plan and it looks like at some point in the future the child or children may be removed from the custody of the parents. It's really a case-by-case determination of the Department of Children and Families, Family First Network, as well as the Guardian Ad Litem program as to what they believe the future of the case is going to be. The next step in the process is another judicial review, and the primary judicial review that is held after this point is what's called the permanency judicial review. Parents in the state of Florida who have had their children removed from their custody have 12 months from the date of the removal to work on a case plan and attempt to have their children reunified with them. And the Florida statutes require that at the 12-month point, and again that's 12 months from the date that a child has been removed from the custody of a parent, at that 12-month period, the court must make a finding of permanency for the child. Optimally, at that 12-month point, reunification will be the primary permanency goal. At that 12-month point, the court must make a determination as to whether or not the parents have substantially complied with the case plan, have addressed the issues that brought the matter into court, and whether or not the children can be safely reunified with their parents. And again, optimally, that is what we're looking for at that 12-month point. However, if a child cannot be reunified with a parent at that judicial permanency review, the second goal in order of preference is a goal of adoption. The philosophy behind the permanency requirements is that kids are kids and they're only kids for a short time and they deserve to be kids and they deserve permanency. And if they can't be reunified with their parent, then they need to be given the opportunity to have a forever family in an adoptive home. There are occasions where adoption is not going to be the optimal permanency goal if a child cannot be reunified with the parent. There are certain circumstances, certain cases where adoption is not the best way or is not in the best interest of a child. Those circumstances are fairly rare. But if adoption is not the best goal for the child, the next best goal is permanent guardianship. A few examples of where permanent guardianship may be a preferable goal to an adoption goal is where, for whatever reason, the individual that the child has been residing with since removal is not going to be in a position to adopt the child. Numerous reasons why that may occur. Does not mean that the child is not in a safe, secure, and stable placement, but there may be some factor that is going to prevent the adoption from occurring. And You must weigh the question, is it better to leave the child in this home that this child has known for a year with the caregiver that the child is bonded with, or remove the child and place the child with people the child has never met before in a potential adoptive home? Again, this is a case-by-case determination, and usually is a determination that is made after much discussion and much evaluation of all the options that are available. If a child is placed in permanent guardianship, and if the child has resided with that permanent guardian for a 6-month period, the case can be closed. The court does not relinquish jurisdiction of the case, but will maintain jurisdiction of the case until the child is 18 years old. But there's no need to come back to the court for hearings every 6 months, which is when judicial review social study reports are filed and the judicial review hearings are held. There's no need for those continued hearings. The case will in essence be closed with the child remaining in permanent guardianship with the caregiver, and the permanent guardian will receive the appropriate paperwork to enable them to act on behalf of the child until the child is 18. Now, it's important to remember that a permanent guardian is not what is called a plenary guardian. A plenary guardian is an individual that has guardianship not only over the child, but also over the child's property, the child's estate. A permanent guardianship and dependency does not have those powers. However, there would be nothing to prevent a permanent guardian in dependency from going to the guardianship division of the circuit court and obtaining a plenary guardianship should the child have any property or possessions that would require the appointment of a guardian of the property of the child. If permanent guardianship is not the optimal permanency goal for a child, and again, remember, we've gone with reunification being the primary. If reunification cannot be achieved, adoption should be the primary goal. If adoption, for whatever reason, is not an appropriate goal for a child, we then look to see if permanent guardianship is, and if there is someone who will act as a permanent guardian. If none of those top 3 optimal goals is available, the next preference would be placement with a fit and willing relative. And it's called permanent placement with a fit and willing relative, but actually there's nothing really permanent about it. If a child is placed in a permanent placement with a fit and willing relative, the court continues to hold hearings every 6 months until the child reaches the age of 18. And during that time frame, until the child reaches the age of 18, a parent can comply with the case plan and attempt to get their child back. And again, these are used very, very rarely and under very special circumstances. I have actually only seen maybe 1 or 2 in the years that this has been an available goal, but it is out there. And again, there is nothing permanent about it because the child is not permanently placed with a relative. That placement can always change. The last available goal at the judicial permanency review is placement in another planned permanent living arrangement. It's used for children that are over the age of 16, that are placed in foster care, that are looking at independent living and looking at achieving the skills that are necessary to enable them to take care of themselves, support themselves, do whatever is necessary to transition them into adulthood. Children that are come into the system later and that are a little bit older when they come into the system, that don't want to be adopted, that want to continue to stay in foster care and have foster parents that are willing to keep them until they're 18 and potentially beyond the age of 18, often will be appropriate for a goal of another planned permanent living arrangement. One interesting change in our dependency statutes, which are found in Chapter 39 of the Florida statutes, is the continuing care for young adults. And effective January 1, 2014, children who are in foster care at the age of 18 have the ability to remain in foster care until they're 21 years old. There are several requirements, that must be met in order for the children to continue to reside in foster care. They need to be enrolled in some type of school. Some children will not graduate from high school by the time they're 18. They may graduate some point after they reach their 18th birthday. They have the ability to remain in foster care until they graduate from high school. They also have the ability to remain in foster care should they choose to pursue a college degree. They have the ability to remain in foster care if they're working 80 hours a month. In essence, as long as they are working towards their education, working towards obtaining a high school diploma or a GED, working towards obtaining a college degree, working towards becoming an adult and functioning as an adult, they have the opportunity to remain in foster care and continue to have the state support them both with their educational and with their daily living. This just came about, again, it was enacted during the legislative session last spring. However, it did not take effect until January 1, 2014, so we're still waiting to see how this is all going to work. The children that decide to remain in foster care, and actually they remain in foster care unless they opt out. They have the ability, if they change their mind, to opt out after they've been maintained in foster care, but then they have the opportunity to opt back in. And I would imagine there are going to be kids that are going to think, I can do it on my own, and they realize how difficult it is, so they want back into the system. And they do have that ability, although there is a process that they have to go through in order to opt back in. Another part of the statute that is somewhat interesting is children that are enrolled in college. Their dormitory or their apartment may be considered foster care. So kids are not going to be required to stay in a city where they have been raised in a foster home. If they choose to go away to college or university, they have that ability, and their living situation can be considered foster care status. They maintain their foster care status, although they may not technically be living in the foster home. And they will be receiving funds from the state, the independent living funds. It depends on where they're living. If they're living in foster care and residing in the foster home, the funds will, in large part, go to the foster parent. If they're living in a college dormitory, the funds for their daily living expenses will be going to them, and they will be having to pay room and board fees at their college or university or pay for their apartment. Guardians also can remain on the case through the age of 21. However, because the child reaches adulthood when they reach the age of 18, it's the child's decision as to whether or not they want the guardian to continue to be on their case. And again, we have not had that come up yet, so we just don't know how that's going to work out. It's going to have to be a wait and see type of thing. Okay, moving on to termination of parental rights. If at the permanency judicial review, the court determines that reunification with a parent or parents is not appropriate, that the parent is not complied with the case plan to the extent that the issues that brought the child into the dependency system have been remedied and the child can safely be returned to the parent, the preferable goal is adoption. And the department at that point, once the court has accepted the goal of adoption, must file what's called a termination of parental rights petition. The department must allege and then subsequently by trial prove that one of the grounds for termination of parental rights has been established, that it is in the manifest best interest of the child that termination of parental rights be granted, and that termination of parental rights is the least restrictive means to ensuring that the child will be safe. There are a number of grounds for termination of parental rights, and these grounds must be proven by clear and convincing evidence. Dependency cases have to be proven by the greater weight of the evidence. Termination of parental rights, the standard is higher, the burden of proof is higher, and it's clear and convincing evidence that the grounds have been established, that it's in the manifest best interest of the child, that TPR be granted, and that TPR is the least restrictive means. Clear and convincing is not as high a standard as the standard in criminal cases, which is beyond and to the exclusion of every reasonable doubt. It's in between the two. It is higher than greater weight, not as high as beyond reasonable doubt. The first ground for termination of parental rights is where the parent has actually executed a voluntary surrender of their parental rights. And if a termination of parental rights is based upon a voluntary surrender of a parent, the guardian ad litem program does not need to be appointed in that case. Often we have cases where the department files a termination of parental rights petition and they allege numerous grounds, and we're preparing for trial, and the parent makes the decision during the process to execute a surrender of their rights. We're already on the case at that point, so we would stay on the case until the conclusion of the case. But if the case is initially filed as a voluntary surrender termination of parental rights, it's not necessary for the guardian to be appointed. The second ground for termination of parental rights is abandonment, and that is where a parent has not engaged in meaningful attempts or efforts to maintain a parent-child relationship, be it via visitation, be it via supporting the child. We have a number of cases, and have had a number of cases over the years, where abandonment may be a ground involving one or both of the parents. Situations where a parent has had no contact with the child at all, sometimes since birth, sometimes since the case began. Parents may start out having a lot of contact with the child and then back off and not have any contact with the child from a certain point on. But abandonment of a child is a second ground for termination of parental rights. The third ground is when the parent or parent engaged in conduct toward the child or other children that demonstrates that the continuing involvement of the parent in the parent-child relationship threatens the life, safety, well-being, or physical, mental, or emotional health of the child, regardless of the provision of services. We call this the threatened harm grounds for termination of parental rights, that the parent's conduct toward the child threatens the life, safety, health, welfare, well-being of the child. The fourth ground is what we call the incarceration statute. And there are several parts of the incarceration statute that can pertain to different circumstances. The first basis for finding TPR when a parent is incarcerated is when the period of time for which the parent is expected to be incarcerated will constitute a significant portion of the child's minority. When determining whether the period of time is significant, the court is to look at the age of the child's need for a permanent and stable home. And the period of time of the parent's incarceration begins on the date that the parent enters into incarceration. This is a significant change from the way the statute was just a few years ago. Previously, the court had to find that the parent would be incarcerated for a substantial portion of the child's remaining minority. And that actually resulted in some almost nonsensical results. You could have a child who was 3 years old with a parent who was going to be incarcerated for 5 years, getting out when the child is 8, and the court finding that's not a significant portion of the child's remaining minority. The truth is, it is. A 3-year-old child who does not have access to or any contact with the parent for a period of 5 years, that is a significant amount of time in the life of a child. On the other hand, you could have a 15-year-old whose parent was going to be incarcerated for 2 years until the child is 17, and using the mathematical calculation that the courts were using under the old statute, that's 2/3 of the child's remaining minority, which would be a significant portion or a substantial portion. So the statute was amended 2 years ago in an attempt to make the incarceration period more compatible with real life and look at the incarceration of a parent from a qualitative as opposed to a quantitative point of view. What is the quality, what are the quality issues that are involved? What effect is having a parent out of a child's life, a baby's life, for a period of 5 years? What effect does that have on the child from a quality standpoint versus just a straight mathematical calculation? And the other change that came about 2 years ago, initially the Supreme Court of Florida had ruled that you measured the length of incarceration from the date the TPR petition was filed forward. This statutory change amended that and made it from the date the parent enters into incarceration. And that's a logical, practical way of looking at it. If a child is 3 years old and the parent's already been incarcerated for 2 years and is going to be incarcerated for another 5 years, that baby doesn't know the parent at all. So it makes more sense to go from the date of incarceration, even if it precedes the termination of parental rights, even if it precedes the dependency case, and look at the total amount of time that the parent has been out of the child's life. The second basis under the incarceration statute for termination of parental rights is where the incarcerated parent has been determined by the court to be a violent career criminal, an habitual felony offender, an habitual violent felony offender, or a sexual predator, or whether the parent has been convicted of first or second degree murder, or sexual battery that is a capital life or first degree felony. So if you have a parent that fits any of those criteria, habitual violent felony offender, violent career criminal, sexual predator, has committed a murder, or has committed a sexual battery that is either a capital life or first degree felony violation, that is grounds for termination of parental rights. Ground under the incarceration statute is where the court determines by clear and convincing evidence that continuing the parental relationship with the incarcerated parent would be harmful to the child, and for that reason termination of parental rights is in the best interest of the child. In making this determination, the court looks at a number of factors: the age of the child, the relationship between the child and the parent, the nature of the parent's current and past provision for the child's developmental, cognitive, psychological, and physical needs, and the parent's history of criminal behavior, which may include the frequency of incarceration and the unavailability of the parent to the child due to the incarceration. And then there's a catch-all factor, any other factor that the court may deem relevant. This statute, as written, again, is fairly new. It was put into being 2 years ago and accounts for those situations where the parent may not be incarcerated for a significant portion of the child's minority, but is in and out of incarceration. A parent who may not have been incarcerated when the case began, when the dependency case began, but then becomes incarcerated, gets out, goes back in, gets out, goes back in, and that same history may be what the child has lived through before the case even came into dependency court. It's an attempt to, statute is an attempt to take into consideration those cases where the parent has been largely absent from the child's life. There's not an established relationship between the parent and child because of the parent's frequent incarceration. The parent has not supported the child financially or emotionally or physically or psychologically during the course of the child's life because of the parent's frequent incarceration. The next factor for termination of parental rights, or the next grounds for termination of parental rights, is where the parent continues to abuse, neglect, or abandon a child, and the basis for that finding is when the parent has been provided a case plan but has failed to substantially comply with that case plan during the 12-month period following the child's removal from the parent. that is the basis for termination of parental rights, because the parent has failed to remedy the situation that brought the case before the court in the first place. Category under the breach of the case plan grounds for termination of parental rights is where a parent or parent has materially breached a case plan. And this is a grounds that will be used prior to the expiration of the 12-month period from the date of the child's removal. Because time is of the essence for permanency of children in the dependency system, the parents are given 12 months. However, if it becomes apparent during the course of that 12 months that the parent cannot comply with the case plan within the 12-month statutory period, the court can find the parent in material breach of the case plan and terminate the parent's rights. The next ground for termination of parental rights is what we call the egregious conduct ground, and that is where the parent or parents have engaged in egregious conduct or had the opportunity and capability to prevent and knowingly failed to prevent egregious conduct that threatened the life, safety, or physical, mental, or emotional health of the child or the child's sibling. Egregious conduct is not clearly defined in the statute, but is defined as abuse, abandonment, neglect, or any other conduct that is deplorable, flagrant, or outrageous by a normal standard of conduct. Egregious conduct may include an act or omission that occurred only once, but was of such intensity, magnitude, or severity as to endanger the life of the child. An example of egregious conduct: a 4-month-old baby with 16 broken bones that are in various stages of healing. Baby's bones at the age of 4 months are very pliable, and it is very, very difficult to fracture the bone of a baby, and it would take severe, intense force to result in that kind of an injury. A horrible car accident could result in a baby suffering numerous broken bones. But when you see a baby 4 months old with 16 broken bones throughout the child's body in various stages of healing, and there's no indication that the child has brittle bone disease or was involved in a terrible accident, that's egregious abuse. Additionally, under the egregious abuse factor or grounds for termination of parental rights, the egregious abuse does not necessarily have to be inflicted on the child that is the subject of the TPR petition. It can be abuse inflicted on the child's sibling, and sibling is actually very broadly defined in the statute. It does not necessarily have to be a sibling related by blood. It can be another child who's residing in the home. It could be a step sibling. It could be a cousin, as long as it is a child that is residing in the home. It is, again, not necessary that the egregious abuse be inflicted on every child in the home. If it's inflicted on one, that can be a basis for termination of parental rights on the other children residing in the home. The next factor or next grounds for termination of parental rights is where the parent or parents have subjected the child or another child to aggravated child abuse as defined in the criminal statutes, sexual battery, or sexual abuse as defined in Chapter 39, or chronic abuse. If a parent has subjected a child to any of these, aggravated child abuse, sexual abuse, chronic abuse, that is the basis for termination of parental rights. And I don't believe you even have to have a conviction. It is enough if you can establish that the abuse, be it physical or sexual or chronic, occurred. The next factor, where a parent or parents have committed the murder, manslaughter, aiding or abetting the murder, or conspiracy or solicitation to murder the other parent or another child, or a felony battery that resulted in serious bodily injury to the child or to another child. Sadly, we have had cases where one parent has murdered the other, and that is grounds for termination of parental rights. Sadly, we've had cases where one parent has murdered a child, and that is grounds for termination of parental rights as to other children. The next ground for termination of parental rights is where the parental rights of the parent to a sibling of the child have been terminated involuntarily. More simply put, if we have a child in the dependency system, the child has an older biological sibling, a termination of parental rights, involuntary termination of parental rights was filed against the parent, and the court granted the termination of parental rights, that is the basis for termination of parental rights as to an afterborn child. Now, if a parent signs a surrender, that is not an involuntary termination of parental rights. That's voluntary. So that could not be used, that act of signing a surrender could not be used as a basis for terminating the parent's rights to a subsequently born child. However, unfortunately, in our system, we do have a lot of children who have older biological siblings, and there was an involuntary termination, and that is a ground that is used quite frequently in our system. The next ground, the parent or parent has a history of extensive, abusive, and chronic use of alcohol or a controlled substance, which renders them incapable of caring for the child, and have refused or failed to complete available treatment for such use during the 3-year period immediately preceding the filing of the petition for termination of parental rights. This is a fairly new ground. We've not seen it used that often, but it is available. Parent has a history of severe substance abuse. They've refused or failed to complete available treatment during the 3-year period preceding the filing of TPR. Next ground, a test administered at birth that indicated the child's blood, urine, or meconium contained any amount of alcohol or a controlled substance or metabolites of such substances, the presence of which was not the result of medical treatment. And the biological mother of the child is the biological mother of at least one other child who is adjudicated dependent after a finding of harm to the child's health or welfare due to the exposure of a controlled substance or alcohol, after which the mother had the opportunity to participate in substance abuse treatment. So, in a nutshell, a child is born, there is alcohol or some other type of controlled substance in their system when they're born via testing of blood, urine, or meconium that was not as a result of the mother receiving medical treatment during the birth of the child. And there's a history of the same biological mother giving birth to at least one other child who was adjudicated dependent after a finding of harm based upon substance abuse and exposure to a controlled substance, after which the mother had the opportunity to participate in treatment. Again, sadly, too often many of our children are exposed to substances, and there is a long, long history of the mother's continued substance abuse prior to the child's birth. The next ground, on 3 or more occasions, the child or another child of the parent or parents has been placed in out-of-home care pursuant to Chapter 39, and the conditions that led to the child's out-of-home placement were caused by the parent or parents. Without trying to sound trite, this is the 3-strike rule. If a child has been removed 3 times from one or both of the parents, or either of the parents, and the reasons for the child's removal, or another child's removal, a sibling, or as a result of the parent's actions, that's a grounds for termination of parental rights. And again, it all goes back to children need permanency. And constant removal, return, removal, return, removal is not in the best interest of a child. That is not permanency, that's confusion, and that's chaos. Finally, the last ground for termination of parental rights is one that was added during the last legislative session. And it is a ground where the court determines by clear and convincing evidence that the child was conceived as a result of an act of sexual battery made unlawful pursuant to the Florida criminal statutes. A petition for termination of parental rights under the paragraph can be filed at any time. The court must accept a guilty plea or conviction of unlawful sexual battery as conclusive proof that the child was conceived as a violation of criminal law. And I view this as not only a child that's born as a result of the rape of an adult, it's also that a child that is born as a result of the rape of a child. And if an individual, a man, is convicted of sexual battery on a child who then gives birth to a child, that can be used as a basis for termination of parental rights on that child. Or if the child is conceived as a result of an adult rape on another adult. But unfortunately, we do have situations in our cases where children have been sexually battered by an adult male and become pregnant and give birth. And so this would be a grounds for termination of parental rights as to the criminal offender's parental rights. Once one of the grounds, and it only takes one of the grounds found in Chapter 39.806, which is the statutory section that contains all the grounds for termination of parental rights. Once the grounds for termination of parental rights have been established, the court then needs to engage in an evaluation as to whether or not it's in the manifest best interest of the child that termination of parental rights be granted. And the manifest best interest factors are found at Section 39.810 of the Florida statutes. One thing that it's important to keep in mind is that in looking at manifest best interest, the court's consideration is not to include a comparison of the attributes of the parents versus the attributes of the people that are providing care. Chapter 39 does not guarantee a perfect parent. Chapter 39 attempts to guarantee that a child will be safe and well cared for in their home. And while children may be in a wonderful foster care placement or in a wonderful relative placement that is an upper middle class home in which they are provided not only with the necessities but with all the extras, that is not a basis for terminating the parent's rights. If a parent has complied with the case plan and can provide the child with a safe home and meet the child's needs, then termination of parental rights may not be in order as relating to those parents, just because they might have a nicer, better home with someone else. There are 11 factors that the court is to look at in determining whether it is in the manifest best interest of a child that parental rights be terminated. The first factor is whether there is any suitable permanent custody arrangement with a relative of the child. However, the availability of a non-adoptive placement with a relative is not to receive any greater consideration than any other factor that weighs on the manifest best interest of the child, and may not be considered as a factor weighing against termination of parental rights. If the child has been in a stable or pre-adoptive placement for at least 6 months, the availability of a relative placement may not be considered as a grounds to deny termination of parental rights. In other words, if a child has been placed in a placement for a period of 6 months, it is a stable placement or a placement where the individual wishes to adopt the child. If a relative then comes into the picture at a later date, that is not to be used as a basis to deny the termination of parental rights. The second factor under manifest best interest is the ability and disposition of the parent or parent to provide the child with food, clothing, medical care, or other remedial care recognized and permitted under state law. In other words, how has the parent cared for the child? Has the parent shown the ability as well as the disposition to provide the child with the necessities of life? And there's a difference between ability and disposition. A parent may have the ability to support their child. They may have a job or other financial means to support the child. But the second part of the question is, do they have the disposition? Are they using the money that they earn at their job or the money that they receive through other legal means to actually support their child, or are they spending it on something else? The third factor is the capacity of the parent or parents to care for the child to the extent that the child's safety, well-being, and physical, mental, and emotional health will not be endangered upon the child's return home. Again, do the parents have the capacity, the ability to care for the child so that if the child is returned to the home, the child will be safe? The fourth factor relates to the child, and that's the present mental and physical health needs of the child and such future needs to the extent that future needs can be determined based upon the present condition of the child. Is this a special needs child? Special needs either relating to physical special needs or medical special needs or mental health or emotional special needs? And what future needs might this child have to the extent that future needs can be ascertained? This really is a factor that's looking at, is this a child that is a potentially adoptable child? Or does this child have such serious needs that it might be difficult to find an appropriate adoptive match for the child? That doesn't mean that a child with special needs should not be considered for adoption, or that a child with special needs parents' rights should not be terminated. It's just a factor that the court is to look into in an attempt in weighing what is in the manifest best interest of the child. Over the years, we have had children who, because of serious medical needs, were not necessarily going to be children that would be readily adoptable. And a consideration had to be made as to whether or not we should move forward with the termination of parental rights and seek to find a forever home for this child, or is a child with a medical foster parent who's willing to keep that child and love that child and raise that child as their own forever, but for whatever reason, largely financial, could not adopt the child. In that situation, it may be in the manifest best interest of the child the parental rights not be terminated. And those cases are so far and few between. And over the course of my years with the program, I've seen children with extreme special needs adopted. But it is a factor the court's to consider. The fifth factor that the court is to consider, which is really a two-pronged factor, is the love, affection, and other emotional ties existing between the child and the child's parents, siblings, and other relatives, and the degree of harm to the child that would arise from termination of parental rights and duties. So, love, affection, and other emotional ties, and then degree of harm that may result from the termination of parental rights. And this is a factor that a lot of our guardians struggle with, because in many, if not most of our cases, there are strong ties between the parent and the child. Children love their parents, and they will always love their parents, sometimes regardless of how abusive the parents have been to them. That's still their mother or their father, and the mother or father that they've known. And it's okay to say, yes, there are strong ties. That's the truth, if it's the truth in your particular case. And it's fine to advise the court that, yes, there is love, there are other emotional ties that exist between the child and the parent, or the child and other relatives. The second part of the test or factor is what would be the harm to the child that would result from the termination of parental rights. And in some cases, there will be some harm. Severing that parental relationship, that parent-child relationship, may cause some harm to the child. The issue is, does that one factor outweigh the need to ensure the child's safety, to ensure the child's permanency? And most of the time it's not. The next factor is the likelihood of an older child remaining in long-term foster care upon termination of parental rights due to emotional or behavioral or any special needs of the child. And I think you need to graft onto this factor another factor, being that older children have the ability to consent and have the right to consent to their adoption. And we have had over the years older children who decided they did not want to be adopted. They didn't want to sever the ties with their biological families, or while they didn't have a concern about severing the ties with their biological families, they did not want to be adopted by anyone. They wanted to remain in the foster home where they were living until they reached 18, and then they wanted to go out on their own. So that is a factor that is to be considered, not just an older child staying in foster care because they have special needs, either emotional needs or behavioral problems or any other special needs, but also because of what they want and what their desires are and whether or not they're actually going to consent to their own adoption. The seventh factor that the court is to consider under manifest best interest is a child's ability to form a significant relationship with a parental substitute and the likelihood that the child will enter into a more stable and permanent relationship as a result of the termination of parental rights. This information is often gathered by our guardian. Family Services Counselor will also provide information with respect to this factor, but it comes from observing the child with their caregiver. Has the child demonstrated the ability to form a bond with a parental substitute, such as a foster parent, such as a relative, such as a non-relative with whom the child has been placed? And the court is going to be looking to the guardian ad litem to provide information based upon the guardian's visits with the child on a regular basis. Is it likely that if the court terminates the parent's rights, that based upon the child's ability to form a bond with a parental substitute, that the child will enter into a more stable and permanent relationship with another individual if termination is granted? The eighth factor that the court considers is the length of time that the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. That actually is a factor that's found in the family law section of the Florida statutes and is also carried over into dependency. And you look at how long has the child lived in the current placement that the child is residing in. Is that current placement a potential adoptive placement? Is it stable? Is it satisfactory? And is it desirable that that placement continue? The next factor, which is the ninth factor, is the depth of the relationship existing between the child and the present custodian. And that kind of dovetails on the previous two factors. Has the child formed a bond with the parental substitute? Is the child likely to enter into a more permanent relationship? How long has the child been in the current placement? How desirable is it to maintain continuity? And then you look at the depth of the relationship of the child and the present custodian, which will provide you information relating to the previous two factors. The next factor is the reasonable preference and wishes of the child. If the court determines that the child is of sufficient intelligence, understanding, and experience to express a preference. Rarely does this factor wind up being presented during a termination of parental rights trial, because most of the children that we deal with in TPR cases are too young to express a preference. And that's not something that we as guardians will ask of younger children. It's a hard question, and it's a tough question for a child to answer, because you're basically asking the child, do you want to end the relationship with your parents forever? And no child should be put on the spot answering that question. Often children will give you the answer by what they say to you, by their actions, by the relationship that you observe with their current custodian, be it a foster parent or a relative, be it by your observation of the child during visitation with their parent. How bonded do they appear? Do they seem to treat their parent as a parent, or is it a playmate during a visitation? How does the child react when the visitation ends and the parent leaves or the child leaves? Now, older children may tell you exactly what they want. And in fact, the older the child, the more likely they are going to. But younger children often, while you are not going to ask them, and you shouldn't ask them what their preference is, you can glean what their preference is by observation of their behavior. Finally, the last factor, factor number 11, is the recommendations for the child provided by the child's guardian ad litem or legal representative. We make recommendations at termination of parental rights cases based upon all of these manifest best interest factors, based upon your observations and your relationship with the child, your observation of the child with the parents, your observation of the child with the caregivers, and all the knowledge and information that you develop during the time that you are on the case. The last factor for termination of parental rights is what is called the least restrictive means factor. And it pertains to whether termination of parental rights is the least restrictive means to ensuring the health, safety, welfare, well-being of the child. And generally, it pertains to whether or not the parents have been offered a case plan. A case plan with services that are geared towards remedying the situation that brought the child into care, and whether the parent had the opportunity to comply and whether they did comply. That is what least restrictive means. However, it's also important to note that other than the case plan or lack of case plan compliance factor or grounds for termination of parental rights, the department or any other person with knowledge is not required, other than on the case plan factor, to offer a case plan to the parents. Of all the grounds for termination of parental rights, abandonment, surrender, incarceration, egregious abuse, all of the other factors that we've gone over, the department, with the exception of where they offer a case plan, are not required to offer a case plan. For example, if you have a case of egregious abuse where you have a 4-month-old baby with 16 broken bones, the department is not required to offer those parents a case plan. They can move directly to termination of parental rights. If this is a third removal, the department is not required to offer the parents a case plan. They can move directly to termination of parental rights. If a parent has been convicted of murdering the other parent or another child, the department can move directly to termination of parental rights. If, however, the department opts to offer the parents a case plan and require them to comply with the case plan in order to get their children back, the department is required to exercise reasonable efforts to ensure that the parent has the opportunity to comply. In other words, they need to make sure that the services that they offer, the services that they recommend, are available, and that a parent is not being required to participate in a service that is nowhere to be found. If the department does offer a case plan and exercises reasonable efforts to attempt to enable the parent to comply with the case plan, least restrictive means will be established. But candidly, on all the other grounds, if the department goes directly to TPR, it's not necessary to offer a case plan to reunify the parent and the child. If they opt to move directly to termination of parental rights on any of the other grounds, that is an acceptable course of action.